The verdict arrived on a Tuesday, not in a courtroom, not with the drama of a gavel coming down and a judge reading aloud from the bench, but quietly, remotely, released as a digital document while Prince Harry was visiting his homeland for the first time in months. He was in Britain trying to repair something, and the news found him there, on English soil, like an old wound reopening. What followed would become the most financially devastating legal defeat of his life. And the question that has haunted royal observers and legal analysts ever since is not simply about money, though the figures are staggering enough on their own. The deeper question is about judgment, about what drives a person, even a prince with every advantage of counsel and resource, to press forward on a path so risky that those closest to the situation quietly admitted the outcome was, in their own words, not altogether unexpected. This is the story of how Prince Harry's most ambitious legal battle, 4 years in the making, 9 weeks in a London courtroom, 47 witnesses, 97 separate claims, ended in total defeat, and why the bill that is now arriving at his door may be the most consequential reckoning of everything that has come after his departure from royal life. To understand what happened in that courtroom, you have to go back further than the lawsuit. You have to go back to the person Harry has said he was trying to become when he walked away from everything he had known. He was born Henry Charles Albert David on September 15, 1984, the younger son of the Prince and Princess of Wales. And from his earliest years, he occupied a particular kind of position that is genuinely difficult to describe from the outside. Second in line to his brother, second in consideration in the endless choreography of royal appearances, second in the inheritance of purpose and duty that the institution demands. He was, by many accounts, the more emotionally expressive of the two brothers, quicker to laugh, quicker to feel, and by his own telling in the years that followed, quicker to carry wounds that the palace never gave him permission to acknowledge. The death of his mother Diana in 1997 left something in Harry that never quite closed. He was 12 years old, and those who watched him grow up in the public eye remarked again and again on the cost that grief seemed to exact. He spoke about it eventually, decades later, with a candor that was unusual for a member of that family. He said he had run from it. He had buried it. He had found his way into the army, into the camaraderie of service, into Afghanistan, where the rules were clear and the threats were visible, and a man knew what he was fighting for. The Invictus Games, the sporting competition for wounded, injured, and sick servicemen and women that Harry founded in 2014, came from that same place. Not from policy or institutional directive, but from a man who had seen what service costs a human body and a human spirit, and who wanted to do something that mattered on terms he could define for himself. Whatever else has been written about him in the years since, Invictus remains a genuine legacy, one built from personal understanding rather than inherited obligation. And then Meghan came into his life, and then the scrutiny that had always surrounded him became something different, sharper, more personal, touching not just him, but the woman he loved, and eventually their children. The coverage that the couple attracted, and the way Harry described that coverage in court documents, in interviews, and eventually in his memoir, was not the story of a man playing victim for public sympathy. It was the account of someone who believed, with real conviction, that something was being done to his family that was wrong, and who was willing to spend years and millions of pounds trying to prove it. That conviction is the thread that runs through everything that came afterward, including the lawsuit that just collapsed around him. Prince Harry's case against Associated Newspapers, the publisher of the Daily Mail, the Mail on Sunday, and Mail Online, was the last outstanding legal action the Duke had brought against British media organizations since 2019. It sat at the end of a long trail of litigation that had, at various points, produced real vindication. Against Mirror Group newspapers, Harry had been awarded $140,600 in damages. Against News Group newspapers, the publisher of The Sun, he reached a settlement in January 2025 that was believed to have exceeded $12 million, with the publisher also required to issue a formal apology for intruding into his private life for more than a decade. Those settlements and victories gave the A&L case a momentum that perhaps made it harder to step back and assess with cold eyes. When you have proved your case against one institution and settled on favorable terms with another, it is natural to believe that the third battle will follow the same arc. Royal legal observers noted at the time that Harry appeared to be approaching this final case with a sense of historical completion, a last chapter in what he had described as his life's work, holding British tabloid journalism to account. The case involved serious allegations. Harry, along with Elton John and 5 other prominent British figures, accused Associated Newspapers of phone hacking, tapping landlines, and blagging, obtaining personal information through deception over a period spanning nearly 30 years. Across 97 separate articles, the claimants allege that journalists had used private investigators to unlawfully gather information about them, their relationships, their movements, their private lives. The trial itself, which ran for 11 weeks in a London courtroom, was billed as the final round in Harry's battle with the British tabloids, with his lawyer alleging that the papers had engaged in a clear, systematic, and sustained use of unlawful information gathering for 2 decades. Harry took the stand himself. He gave evidence in person. Those who followed the proceedings closely noted that he spoke with the intensity of someone who had been carrying these beliefs for years and finally had the forum to lay them out. But Justice Matthew Nicklin, the judge overseeing the case, observed something in the way Harry testified that would later find its way into the written judgment. He noted that in assessing Prince Harry's evidence overall, it was apparent that he wished the court to understand the personal impact of the matters in issue. At times, this led him beyond giving factual evidence into advancing arguments on the issues. That observation mattered, because at the heart of this case was not a question of how Harry felt, or whether the coverage of his life had been relentless and intrusive. Evidence suggested it had been. The question was whether the claimants could prove that specific articles had been obtained through specific unlawful means. And that is where the case ultimately came apart. Judge Matthew Nicklin ruled that the claimants had not proved that information had been gained unlawfully, and every one of the 97 allegations of unlawful activity was dismissed. Every single one. There's something almost suffocating about that number when you sit with it. 4 years of preparation, 9 weeks of testimony, dozens of witnesses, millions of pounds spent on legal preparation on both sides. And at the end of it, the judge found that not one of the 97 claims had been established to the required standard of proof. Justice Nicklin rejected the broad inferences the Duke of Sussex relied on to try to show that Associated Newspapers had engaged in unlawful activities. He said there was a shortage of evidence to support the claims, and found a possibility that the news stories came from legitimate sources. The judgment ran to hundreds of pages. One thread that ran through it involved a key witness, a private investigator named Gavin Burrows, whose evidence was central to what the claimants were trying to establish. Burrows had apparently made a witness statement in 2021 claiming he had conducted illegal activity for associated targeting possibly thousands of people. But in court, he said he had never signed such a statement. He indicated the signature had been faked and traced. The judge found that Burrows' credibility had been, in the judgment's own phrasing, comprehensively undermined. When a central witness's testimony collapses in that way, when the foundation on which a significant part of a case rests turns out to be unreliable. Everything built on it becomes precarious. And royal legal observers noted in the days following the verdict that the collapse of Burroughs' evidence had left a gaping hole in a case that was already being described by some legal analysts as built primarily on inference rather than direct proof. The ruling noted, in language that felt quietly devastating for the claimants, this was always a mosaic case where little inferences from different things were being put together by the lawyers for Prince Harry. Associated Newspapers lawyers cleverly rearranged the tiles to show an innocent picture as opposed to the culpable picture that the claimants' lawyers were trying to demonstrate. A mosaic rearranged. That image captures something true about what happened in that courtroom. Harry had brought a picture he believed he could see clearly, a pattern of wrongdoing stretching back decades, and the court looked at the same tiles and found something different in them. The verdict arrived while Harry was in Britain. The timing was not planned that way, but the coincidence carried its own weight. He was there for Invictus-related events, marking a year to go before the 2027 games come to Birmingham. He was also there because, quietly and tentatively, something had been shifting between him and his father. The Sussex family's July reunion with King Charles and the children's grandfather had been emotional and, sources suggested, left both father and son hopeful about future possibilities. It was not a clean reconciliation. The path back is never clean in families fractured this deeply, but it was something, a thread being picked up. A door left ajar rather than pulled shut, and then the verdict came through. Harry and Baroness Doreen Lawrence, one of the other claimants, issued a joint statement that called the judgment a complete and obvious whitewash. They wrote that they had come to court seeking justice and accountability, but believed they had received neither. They pointed to what they saw as contradictions between this ruling and earlier decisions in related cases against other publishers. Paul Dacre, the long-serving former editor of the Daily Mail, and one of the figures most personally implicated in the culture the claimants had alleged, called the ruling a momentous victory. He described the lawsuit as a trumped-up action that should never have been brought to trial. The gap between those two responses tells you everything about how differently the same set of facts can be read when they are filtered through decades of mutual hostility. Harry and the press who pursued him have been in this particular dance for the entirety of his adult life. What the court determined is that Harry could not prove, in the way that courts require proof, that the steps of that dance included the specific criminal acts he alleged. That distinction between what you believe happened and what you can demonstrate happened is one that the British legal system applies without sentiment. And it is a distinction that would cost Harry in ways that are only now becoming fully clear. The financial reckoning began almost immediately after the verdict. Associated Newspapers indicated that costs of more than £50 million had been expended in defending the case. Court filings suggested the judge would ultimately consider a slightly lower figure of approximately £34.5 million said to have been spent by the Mail. Under normal legal principles in England and Wales, the losing side pays the winner's costs. That alone would represent an enormous liability. But Associated Newspapers was not asking for costs on normal terms. The publisher was asking for something more severe, something called indemnity basis assessment, which is a more punitive scale applied when a court finds that the losing party's conduct has been sufficiently unreasonable to warrant it. At the start of a 2-day costs hearing that began on July 29, 2026, Associated Newspapers demanded an immediate payment on account of nearly £10 million from Prince Harry and the other claimants, to be paid within 14 days of any court order. The publisher argued its costs should be assessed on the indemnity basis, a more punitive scale that could lift any cap on recoverable fees and push the total bill toward £34 million. And the joint statement Harry had issued calling the judgment a whitewash, that became in the hands of the Associated Newspaper's legal team, another piece of ammunition. A&L's legal representatives cited the conduct of the claimants and their legal teams in the case, specifically referencing that statement. The filing argued that the statement sought and achieved global publicity for a continued allegation that Associated was in fact guilty of the wrongdoing alleged, even after a court had just ruled otherwise. There is something quietly instructive about that argument. When you are fighting over legal costs and the other side is trying to convince a judge that your conduct was unreasonable, calling the judge's ruling a whitewash in a statement designed to reach global audiences is not, by most assessments, the most strategically prudent thing to do. Royal observers noted in the days following the costs hearing that the whitewash statement had given A&L precisely the ammunition it needed to make the case for a harsher penalty. Now the numbers. The court filings show that Harry and the other claimants had taken out individual after-the-event insurance policies, which collectively provided approximately £16.2 million in coverage. If Associated Newspapers were to be awarded the full amount, the claimants would potentially need to pay £18.2 million from their own resources. £18,200,000. Give or take. That is the figure that has settled into public consciousness as the cost of this defeat. Not the full $34 million. That is what A&L claims to have spent. Not the $50 million they initially floated. But the gap between what the insurance covers and what the judgment could ultimately require. £18 million. That would have to come from somewhere other than a policy taken out years ago when the world and the case both looked rather different. The publisher was pursuing up to £34.5 million in legal costs, with the total bill for defending the 4-year litigation said to have exceeded £50 million. The insurance, capped at $16.2 million, was always going to fall short if the judgment went against them. What was not fully understood until the cost hearing was precisely how far short it would fall. The claimant's legal team argued that the indemnity costs approach was inappropriate, noting that A&L's incurred costs exceeded its approved budget by more than £18.6 million, reflecting what they called an astonishingly high legal spend and an entirely cavalier approach that had overridden the principle of proportionality. But the counter-argument, made with some force by A&L's representatives, was that the scope and seriousness of the allegations justified the expense. The allegations had named no fewer than 77 journalists, editors, and executives, and accused them of serious wrongdoing, amounting in many cases to criminal conduct, though only 23 were ultimately involved in the claims. And some of those allegations were, in the court's telling, abandoned during the trial without apology. The judge has not yet issued a final ruling on the costs. That is the ground on which the legal battle now continues, shifted from the question of whether A&L did these things to the question of how much Harry and his co-claimants must pay for failing to prove that it did. And the outcome of that hearing will determine whether $18 million is the number, or whether it ends up being something lower, depending on how the judge assesses the conduct on both sides. What does this mean for a man's life? Not for his public position, not for his legacy, but for his actual financial circumstances? Prince Harry's estimated net worth has been placed at around $60 million by various financial analysts over recent years, though such estimates always involve considerable approximation. And the figure represents not just cash, but the combined value of property, investments, and ongoing commercial arrangements. By any reasonable standard, Harry is wealthy. He will not be made homeless by this legal defeat, but the context matters enormously. The Sussexes' landmark deal with Netflix, thought at the time of signing to be worth approximately £80 million, was restructured in August 2025 into a first-look deal, meaning Netflix could say no to their projects. This ended the guaranteed large paydays that Archewell Productions had relied upon. The couple would now be paid on a project-by-project basis. In December 2025, the Sussexes were forced to lay off some members of staff from Archwell Philanthropies, with the explanation given that the reduction was due to folding two companies into one. Financial filings around the same time revealed that the Archewell Foundation had $5.1 million in expenses in 2024, while taking in only $2.1 million. That gap, more going out than coming in, tells a story about the structural reality of life outside the royal institution. When Harry and Meghan stepped back in 2020, they announced they intended to become financially independent. In the years since, they built something real. Book deals, the Netflix arrangement, speaking engagements, the Spotify podcast that eventually ended, the lifestyle brand that Meghan has been developing. But commercial success in the market is different from the assured, institutional backing of the monarchy, and the market has been sending mixed signals. Meghan's lifestyle series on Netflix did not continue after its first season. The Polo documentary received a strikingly small audience. The narrative of two globally famous royal figures who could monetize their profiles on their own terms has run into the harder reality that the audience for their content is not unlimited, and the institutional goodwill that might once have smoothed commercial paths is no longer available to them. Into this picture comes an £18 million potential liability. Royal financial analysts have noted privately that even for someone of Harry's wealth, a sum of that magnitude is not trivial. It represents a significant portion of his estimated net worth. It would not ruin him, but it would make the already pressured financial situation of the Sussexes considerably more acute. And there is something else layered into this, something that goes beyond spreadsheets and legal schedules. This lawsuit was not merely a financial venture, it was, in Harry's own framing, part of a moral project. He had described his campaign against the British press as central to who he understood himself to be. He had said it was his life's work. He had spoken of wanting to create change that would protect not just himself, but others who could not afford the legal teams he had retained. The judgment represented a significant setback for Harry, who spent years pursuing legal action against British newspaper groups and described reforming press practices as his life's work. When the thing you have invested years and your identity into is ruled against so comprehensively, not a partial defeat, not a mixed result, but 97 claims dismissed in their entirety, the cost is not only financial, it is existential. It touches the story you have told yourself about why you are doing what you are doing, why you left what you left, why the sacrifice was worth it. Those who study the psychological dimensions of how people carry public failure observe that the danger in such moments is not the immediate pain. The danger is in what happens to the narrative a person has constructed around their choices. Harry had built an account of himself as someone who had seen something wrong and was courageous enough to fight it at great personal cost. The MGN verdict and the NGN settlement gave that narrative real evidence to stand on. But this verdict cuts against it in ways that are harder to fold into the story. Calling it a whitewash, in the public statement released on the day of the judgment, reads, from the outside, through the particular lens of human psychology, as an attempt to protect that narrative from the damage the verdict inflicted. If the judge was wrong, if the system was captured, if the outcome was unjust, then Harry can remain the person he believed himself to be. The alternative, that the case was genuinely weaker than he had convinced himself it was, is a harder reckoning to sit with. His visit to Britain this July had been, before the verdict arrived, generating its own complicated headlines. It emerged in early July that Harry had accepted an offer from King Charles to stay at Buckingham Palace during the visit, before being informed that the offer had been withdrawn following consultation with the king. That withdrawal whatever its precise origins inside the palace, generated a particular kind of media attention, the kind that makes a reconciliation look more fraught than either party would wish to present it. Sources close to the family told various outlets that the Sussex family's reunion with King Charles on July 10th had been emotional and had left both father and son hopeful about future possibilities. But the path to whatever that future holds has been consistently complicated by the institutional layers around both men, advisors, courtiers, protocols, press offices, all of them shaping what is possible and when and under what conditions. A royal biographer writing about this period might observe that the father and son are trying to find their way back to each other across a distance that was built over years and cannot be closed in a single afternoon. Charles is in treatment for cancer, a fact that Harry has spoken about publicly with evident distress. Harry has said plainly that he does not know how much longer his father has. That weight presses on every interaction, every delayed response, every invitation offered, and then withdrawn. And then the court decision came down. The costs hearing followed. And suddenly the conversation about Harry and Britain was no longer about reconciliation at all. The costs hearing that began on July 29th, 2026, is expected to produce a ruling in the weeks ahead. The judge will decide several things. Whether costs should be assessed on the standard basis or the more punitive indemnity basis that A&L is pushing for. A&L had sought an immediate interim payment of just under £10 million, while the claimants had offered an £8 million interim payment. The final sum recoverable, and the question of whether the conduct of the claimants, including the post-verdict whitewash statement, warrants the more severe treatment. Legal analysts note that even if costs are awarded on an indemnity basis, the court retains discretion over the final figure, meaning any sums awarded remain subject to a test of reasonableness. That offers some potential comfort. The 18 million figure is the upper end of personal exposure if everything goes against the claimants. There is a version of events in which the final number, after the judge has considered all of this, is somewhat lower, but the direction of travel is clear. And the question of whether the insurance policies that were meant to cushion this outcome will actually pay out in full, there are concerns in the claimant's camp that an insurer might push back if the judge concludes their conduct was unreasonable enough to merit sanction, adds another layer of uncertainty to an already complicated situation. What is not in doubt is this. Prince Harry will pay an enormous sum of money as a consequence of a legal battle he chose to fight and lost. How enormous will be determined by a judge who will look carefully at the conduct of all parties, and that conduct, including a public statement that attacked the integrity of the court's ruling before the cost question was even resolved, will be part of what he weighs. When you stand back from the figures and the filings and look at the shape of this man's life over the past 6 years, what you see is a person who left something enormous in search of something he could not yet name, and who has been paying for that decision in ways he probably did not fully foresee. He left the institution of the monarchy. He lost, in the process, the certainty of knowing who you are by virtue of the role you carry. He lost proximity to his family, fractured beyond what he or anyone who loved him might have imagined. He lost his security detail. He has spent years and millions of pounds in courts trying to recover what he felt had been taken from him. His privacy, his reputation, his family's safety, his version of the truth about what the British press had done. Some of those battles he won. Against Mirror Group, against News Group. History will record those victories as real, whatever else comes. The journalists and executives who hacked his phone, who traded in stolen details of his private life, were held to account. That is not nothing. That is, in fact, considerable. But the A&L case, the last one, the one he described as the conclusion of his campaign, has ended in total defeat. And the bill is arriving. And the man receiving it is a 41-year-old father of two, living in California, trying to rebuild a relationship with a father who is ill, managing a charitable foundation that is spending more than it raises, watching the commercial empire he and his wife built together face headwinds he could not have fully predicted. None of this is simple. None of it invites easy sympathy or easy judgment. He is wealthy by any standard most people could imagine. He chose these battles, and the cost of losing them falls on him because he chose to fight. But there is something genuinely human in what has happened here. A person who believed something profoundly, who organized the middle chapter of his adult life around proving it, who went into a courtroom and gave everything he had, and came out the other side to find that belief, however sincerely held, had not been enough to persuade a court of law. The legal system does not award costs to sincerity. It does not distribute verdicts based on who suffered most or who deserved justice most keenly. It weighs evidence and standards of proof, and whether the inferences you drew from the available facts were reasonable enough to stand up under rigorous examination. Harry's inferences, the judge found, were not. The £18 million now circling his life is not simply a sum of money. It is the price, in the most literal sense, of a conviction he carried for years and could not ultimately prove. Where does he go from here? There will be an appeal. His legal team has indicated as much, and the issues in a case this complex are rarely resolved in a single ruling. But appeals in English law are difficult. They do not simply relitigate the facts, but must demonstrate that the original judge made a legal error. Given the scope and detail of Justice Nicklon's judgment, which ran to well over 400 pages, that will not be straightforward. There is also the question of what comes next for a man who defined himself for years by this fight. If the press campaign against him was real, and the settlements from NGN suggest parts of it were, but the specific criminal methods alleged against A&L cannot be proved to the court's satisfaction, then Harry is left in a strange liminal space, vindicated in some respects, defeated in others, with the financial consequences of the latter still unfolding. His father's health is uncertain. The Invictus Games are coming to Birmingham in 2027, and Harry has spoken of wanting Charles there. A public reconciliation, a father watching what his son built in the country where they both grew up, and where something between them broke, and is, by small steps, being attempted again. There are Archie and Lilibet, who are being raised in California, knowing they are the grandchildren of a king and the children of a prince, in a country where those facts carry a different kind of weight than they would in Britain. And there is Harry himself, the man who decided 6 years ago that he could not continue on the path that had been laid out for him since birth, who paid for that decision with nearly everything an institution had given him, and who has been searching ever since for what comes next. The judgment that just arrived is not the end of that search, but it is a reckoning with it, a reminder that the choices we make in the name of what we believe can carry costs that arrive slowly, in ways we never fully calculate when we are standing at the door, deciding whether to walk through. He walked through. He has paid for it, and will pay more. Whether it was worth it, whether the campaign against the press, the memoir, the interviews, the lawsuits, the departure itself, is a question only he can answer. And somewhere across the Atlantic, in a house in Montecito, with the Pacific not far away and his children growing up in a life that bears no resemblance to the one prepared for him, Harry is the only person in the world who knows what that answer actually feels like.